Well, thanks for sticking with us through all three sessions. It's good to see everybody again. Why don't we go ahead and get started? I know we want to finish on time and wrap this up. Today's probably the most interesting session, at least for me. Employment investigations are the most challenging part, I think, of HR work. It's the part that calls for every part of your brain. And, you know, today we really want to cover when do you need to do them, how to do them, and we're going to do some really, I think, deep dive hypos, different than the hypos we've been doing in the past, which means you're going to actually do a bit of role playing. So I hope you'll take advantage of that. Carolyn and I have concocted a scenario that is entirely fictitious.
Yes.
Before you pass judgment on our workplace conduct, we will role play the complainant and the responding employee, and try to have you guys walk through a scenario as you might be doing in the wild, so to speak, in your own workplaces. So we'll focus on what kinds of questions to ask, you know, what kinds of things, what's the purpose of an investigation? What are we trying to get at? And then I'll share with you, this was our tech issues at the beginning, a document that is a sort of a template form of an investigation report. It's very difficult to share these as templates because every factual scenario is different, but we'll actually try to work on it together in real time. So when we conclude an investigation, what does that look like? What's our work product going to be? So what we want to try to get to today is the ability to sort of work on that report and give you a vision of what we like to see as attorneys in that kind of an investigation report. So like I said, this is the hardest part, I think, of your job. And we covered ADA already. So that should give you a hint. I'm going to go ahead and share my screen, and we'll start by going through just some slides. This always blocks this. One second. I'm going to minimize this. I'm just going to pull it down. Let me get it. There we go.
All right. So I guess I was just curious when I was preparing for this, who here has conducted a workplace investigation? Is there a way to pull the audience?
We can kind of see them.
Have you done one, a formal one, an informal one? No.
I'm seeing
Yes.
Carol nod, yes.
Carol has.
Have you done?
Not here, but yes.
You have done one in the past.
We're very
Different
well
workplace. Yeah.
Yeah. Okay. So I guess just to kind of give you an overview, workplace investigations, so they are important. You don't always have to do them. You know, we don't need to be on the lookout for this stuff every single moment of the day, but at the same time, knowing how to do these and knowing when to do them is really important because it can protect workplace morale, it can prevent litigation, and it can also serve as sort of in some cases, the most critical defense in the event that you get a claim. So in some cases, the action of the employers, what did an employer do to address a situation, is the most important thing for the employer when they face a discrimination claim or any other sort of workplace misconduct claim that involves an employee's misconduct being complained about by another employee. So by doing an investigation and taking action, you also have to kind of take appropriate action afterwards. But doing an investigation is the first step to protect the organization and to make sure that everything is running appropriately within your organization. And so litigation, yeah, we talk about this every time. We're like the doomsday preppers of litigation world, you know, they're going up, there's so many claims, it's just what we do all day. But at the same time, objectively, when you look, you know, from a bird's eye view, employment discrimination claims filed in the United States continue to rise. Every year there are more of them. And the EEOC, the Equal Employment Opportunity Commission, which is like the federal main human rights commission equivalent, They monitor discrimination claims at a federal level, and they also do their own investigations, and they bring litigation against kind of bad actor employers. So employers who are really egregiously violating the rules, they will actually bring an actual suit against them. So the EEOC is taking a more aggressive stance on workplace discrimination, and they filed more than 50% more claims against employers in 2022 than 2023. I mean, in 2023 than 2022. So it's something to just be really careful about, and having this in your toolkit is going to go a really long way to reduce the likelihood of litigation, and also to make sure that your employees feel like the employer is taking complaints really seriously and treating everyone fairly in the workplace.
I want to pause for just a moment and focus on something that Carolyn said. For those of you who are new, and this used to be, before I would do this kind of work, this used to be my instinctual reaction when I had harassment training, for example, which is, this is never going to come up on my workplace. This is, we don't really harass people or discriminate. We don't employ a bunch of people who are, racist or, whatever. We all like to think the best about. So why do we focus on this so prominently? And, in the HR world, why is this so important? Is it because we think that these, fact patterns are playing out on a daily basis everywhere? Not necessarily. I think what we want to talk about from a legal perspective is that very often, because the United States, like a baseline assumption you can make about employment in the United States is we do not have for-cause termination. We have at will, right? We know that in Maine. We know that generally in most states you have at-will employment. So when somebody's upset about termination or being demoted or suspended, they have only certain kinds of claims that they can bring. And those claims are for money. And so you will get more of these than you expect. I think for new HR people who are walking into this, you should expect to see some of these over the course of your career. Even if you think your workplace is doing everything correctly, you have the right handbooks, you're operating with the right policies, you have a really good workplace culture, you get to a certain number of employees and these claims just do come up. So that's in particular why we want to focus on harassment, discrimination claims, because there's only so many vehicles that an employee can use to raise, unlawful termination claims. And when it happens, you will want to know how you've handled it and that you're doing it appropriately. So I'm curious, before I give the answers in the slide, raise your hand if you think after COVID-19 pandemic and a lot of employees who are office-based, for example, ended up working from home, what do you think happened with harassment and discrimination complaints? Do you think raise your hand if you think they went up, they increased? So people are working from home now. I think probably harassment and discrimination claims went up. Raise your hand if you think they went down. This is everybody. Everybody says they went down. That was exactly our thinking too. Nope. They actually, so not every type of claim, but sexual harassment and workplace harassment, so discriminatory harassment, colleague to colleague, went up. Anybody have ideas why that might be? These are some of the headlines we saw. Why would you think that there might be an increase in, say, race harassment, sex harassment when people are working from home?
So conversations aren't had face to face, so people may take it differently.
People may take it differently. Also, what about context, right? I'm taking this work call and especially early on in the pandemic, before we had set up, home offices or workspaces, I might be in my bedroom, right? Or I might be in my kitchen. You get to see some of my family walking around. There's a level of informality that was overlaid with a lot of the conversations that would normally happen in an office where, you know, we come to work and we have our professional clothing on. And what about the idea, a lot of these phone calls or Zoom video calls might be, oh, Heather's got her hand up. Hey, Heather.
Hey, I was wondering too, with like in the terms of gender harassment, you know, because I think more women took the brunt of caring for kids at home too. So there was, for some who were able to absolutely not work in the office because of that, was their rise and kind of that feeling of you're not doing your work because you're home caring for your kids, and therefore there was more expectations put on. Or
Totally right. We personally had a lot of training that we were doing during that time for a lot of our workplaces on exactly what you're talking about, Heather. You know, don't make assumptions based on gender and sex about who is taking care of family members or children in the house, right? Don't treat people differently. If they have those caregiving obligations, right, check in with your employees and make sure that, you know, they are capable of doing the work. There was a lot that was in flux during those years. There's also a lot of unsupervised, you know, calls, right? So you have, let's say you had a manager or an employee who was maybe inclined to be a bit of a bad actor. Now that employee is having a conversation that's not in the context of a conference room like we're in, where at any point in time, somebody walking by could look in the window and see what's happening, right? Or overhear a conversation or share with each other. So what we found was that a lot of people felt a little bit more liberated. I mean, how many of you remember the Zoom news of employees taking calls from their bathroom, or, you know, being caught in a few compromising situations? So I think all of that contributed to a lot of what we saw in the pandemic. These were a lot of lawsuits that were filed, right? An employee exposing themselves. You would never see this during, you know, in an office. You would hope not. A supervisor demanding a black male employee turning his video on, not requiring white counterparts to do the same, taking screenshots of their colleague and manipulating the photos to emphasize breasts or certain body parts, adding comments. Okay, and then we had an argument in our firm about whether this is GIF or GIF.
Yeah.
Either way.
Uh-oh. The debate continues. Yeah, I've always said GIF, but we will reserve that argument for another day. Phallic emojis through chat, vendors, you know, those of you who know the fruit and vegetable emojis, there are certain ones that have more of a sexual innuendo. Vendors saying an employee's voice sounded sexy and that she should be a sex phone operator during a conference call. I think people were a little bit more liberated to be totally inappropriate.
All right, so when to investigate complaints. So this is step one of our analysis. You just kind of need to have a sense of what incidents, what complaints are going to rise to the level of you wanting to take the next step to conduct the investigation. And the purpose of investigations aren't just to check a box, although as we mentioned before, they do check an important box in terms of showing company action, but they also determine the facts that the company can't know from the complaint alone. So the question is, if the allegations were true, would we take action? So you have to look at it as kind of, take this, you know, it's what we do in litigation all the time. Take this complaint as true. On its face, are you looking at potential legal claims? Are you looking at potential policy violations? And are there kind of moral and ethical norms beyond your policy that would give rise to an investigation? So if you see words like hostile work environment, you know, discrimination, those are kind of key legal terms that might point you to the fact that this may this may require an investigation, or you may be in a better place legally down the road if you do an investigation. All right. So in some cases, the duty to investigate may be dictated by the policies of the organization. So it's important that you're aware of what those policies are, where in the company's handbook a duty to investigate is laid out. And so that's one part of it. The other part of it is when you see formal complaints, when you see informal complaints. But then there's also this other piece, this sort of like middleman piece. When you get a complaint through a supervisor or a manager that they're observing or hearing inappropriate comments or conduct, that's kind of a red flag that even though you haven't gotten a direct complaint from an individual employee, that there's potential inappropriate conduct going on or a policy violation going on that you may need to investigate. And then this is kind of a tricky one because it's a little bit more vague. And you may not even have, we'll talk about this later, but you may not even have all of the information that you need to have in order to really conduct an investigation. You may have to kind of go digging for it more. But when the sense is that, and there are employers like this, when there's a general sense that there's harassing behavior or a cultural problem at the business. So either there's a history of past discrimination or sexual harassment that is kind of trickling into all aspects of the business. So there's not a specific formal complaint that you're going to drill down on, but it's coming in from different avenues, little bits of it. That may be a good point to really try to dig into what the problems are through an investigation.
Let me give I think what might help is for me to give an example of where I've seen this come up for clients who are in that last bullet point situation.
Yeah.
This would look something like this. We had a Christmas party, and at the Christmas party, there were some employees getting very friendly with one another. One of them had a little too much to drink. And, another employee was totally offended by an insinuation or something that she said. We don't have a sex harassment, nothing rising to the level of a legal claim yet, but just kind of a personality conflict between these two employees. And one of them was becoming, a little overly friendly with another one of our employees at this Christmas party. And then 2 weeks later, that same employee who may have overindulged at the Christmas party, we don't have any proof of this, but somebody says they can smell alcohol on her, and she's in the office. And 3 weeks later, there's another personality conflict that breaks out into a bit of a screaming match. You start to get things that are adding up. None of these situations individually necessarily would automatically trigger me to think I need to run an investigation, right? I need to know the context, but let's say I know a little bit more about the context. The comments were nothing to do with any protected class status, just sort of employees being angry. Often the way I hear HR coordinators or HR employees characterize this is it's a whole lot of drama. That's probably the word that gets used most often. That's when I often recommend that the HR director, maybe you're not launching it as formally as you would in, there's a specific complaint and we're responding to a specific complaint, but go find out what happened, who's saying who to what, saying what to whom, and is there one bad apple that is instigating a lot of this, or do we just have a culture problem here? And if you have a culture problem, right, that's setting expectations, increasing policies, things like that. That is prophylactic. You're doing that before you ever need to call me. Or Carol.
All right, so pop quiz time. We'll talk through this together. An anonymous group of individuals started an online petition calling for an investigation into the town's workplace culture.
By the way, for this scenario, because we do have a couple of folks calling in from public, government agencies, so the town is the employer here.
But you can replace this with the individuals who claim to be former employees and concerned citizens state that bias incidents occur frequently, but the petition does not contain any specifics. The petition is making its way across social media, and someone tags the town manager in a post, putting the town on notice. Do you have a duty to investigate this social media frenzy?
Put a thumbs up if you think there is a duty, just based on what we know. Thumbs down if you think, no, I wouldn't even bother. What the heck is a bias?
See.
Ooh, I see thumbs up in the emoji. Nice. All right.
All right, so this is a tricky one. It's a little bit of a trick question because this is sort of one of those situations where what do you even investigate, right? Where do you even start? What do you grab onto? But that doesn't really change the duty piece. Just because there isn't one individual attached to the thing doesn't mean that you shouldn't try to find out more. As Terry was saying before, it might mean that you're looking into this in a more informal way, but you're still investigating. So what would the scope of your investigation be?
Where
That's a hard
maybe
question.
a better question
Yeah.
too, where would you start?
Right.
The people who signed the petition.
What would you ask them?
I guess why they signed it.
This is classic. Every investigation is going to start in a very similar way. Go to the complainant and almost in every case, I can't really think of an example, a counter example. You're going to the complaining group or individuals, the people who have raised this, and you're asking, what do you mean? What is this? How did it happen? When did it happen? Who was involved? Who knew about it, etc.
And then from there, you may get information about who's involved, who's the alleged respondent. If that's the case, then you go, sorry. If that's the case, then you sort of work through your list. You just want to be, you want to think about the order and kind of what information you're trying to get. And in some cases, that may not be the case here, but in some cases, you might want to time things so that individuals, I mean, you're going to instruct them to not speak to anybody about this, but you may want to time things so that there's not a big lag between your interviews, if possible, so that you're not they're not getting a chance to continue the rumor mill and to continue to talk to other people. Is that something you do?
Sometimes it
Yeah.
depends on the investigation. I mean, the fact almost always once you start an investigation, the evidence takes you in a different direction than you expected to go in. It's very rare that it's what you assume it's going to be when you start out. So, you know, I could see this going a bunch of different ways. So bias incidents was something that the town council and, you know, a way that the one of the council members used a particular phrase, for example, and you have it on video, right? So you may not necessarily need to go too much further. You can just review the video itself. But it all depends. I think the best advice is follow the facts. Follow where are witnesses and individuals leading.
I had a recent investigation where the complainant was anonymous. And so that meant that we didn't start at the complainant because we didn't know who the complainant was. So we had to start with the respondent, which was a little bit backwards, the respondent and the alleged witnesses. And in this case, it turned out to be, the whole complaint turned out to be made up as like retaliation.
No.
As retaliation against the individual, and we never figured out who it was.
Wow.
But when we called all the witnesses, they were horrified that they had been implicated in this situation.
Wow.
Because it was completely fabricated.
No wonder it was anonymous.
I know. Yep.
Wow.
Yikes. Okay.
Would it be okay or not okay to email the employees of said company or town and just like, here's a refresher of our anti-harassment policy, and please know that if you would like to discuss, if you're part of a scenario, please come talk to me about it.
Is that in response to this fact pattern? Probably. I think that's putting a little bit of the cart ahead of the horse.
Okay.
I would say I would not recommend that approach because in this factual scenario, you have biased incidents, and if you are on notice, so right, if I'm the town and I want to avail myself, the town attorney, let's say I want to avail myself of any legal defenses that could be available and fully go through my obligation, I'm now on notice that bias incidents occur frequently. And all I know, it doesn't really have more specifics than that, But if my only response is we have an anti-harassment policy, and even if it's, you know, please contact me directly, I've not exercised my obligation to review the scenario and try to get the facts. Let's say, you know, it turns out that what actually these individuals are referring to is a systematic, you know, race-based discrimination campaign between a supervisor and a direct report. And I didn't investigate that. This petition would be used as evidence that that defense wouldn't be available for the town and that we didn't follow our policies. We'll talk about the defense in a little bit more detail. It gets a little bit technical, but I think it can be easily understood and summarized this way. You're not required to be omnipotent. We can't guarantee that employees that work for us are not going to discriminate against other employees. That is just not something, these are all people. People are autonomous, right? They make their own decisions. The only thing we can control as a company or as an employer is what we do in response to that when we know it. And so when you get information like this, it should automatically trigger in your brain a light switch that says, my obligation has been triggered. I need to investigate. Very often, let's just say that this petition, instead of being signed, was anonymous and it says bias incident. So I asked the town manager, I asked a number of people who were listed in this and nobody knows what this is talking about. I closed the investigation. Even if it really happened, I'm actually exercising everything I could do to find that out. And so I fulfilled my obligation.
Okay.
So your obligation is to have the policy. You need to have the sexual harassment policy. You need to have the policy that says we investigate complaints when people make them. And then when you get in reports like this, that you try to find out. That's okay.
All right, wait, do we want to do the second part?
Oh, sorry.
Okay, no, just quickly. Okay, so the same scenario, but now current employees are commenting on the post with their own bias-based experiences. It actually happened in our town. There was like somebody had been on some sort of terrible date with someone,
Oh, no.
and she posted about it on Facebook. The guy was a manager at a local business, and many of his former employees chimed in about all the sexual harassment that he had subjected them to.
Not a client, but where
Not a client. This is just in the town that I live. And so all of a sudden you have this big string of people saying, you know, I was 15 and he was behaving inappropriately towards me, just all in this really unfortunate one spot. So what do you do when you see that?
You call Tara and Carolyn, I think.
Like, we're like, heads
holy moly. Yeah.
Because what it does here is now you have different incidents, and it all may be, you know, it's all part of the same conduct, it may all involve the same respondent, but you have kind of a broader duty to investigate all of these different reports now, wouldn't you say?
I think if it's definitely current employees, 100%, that's an easy one. Tougher one. Yours, not only former employees, let's take that out of the equation. Let's just say dating partner, people in the community.
Yeah.
Definitely Heather agrees. You would have to start with current employees. That's a no-brainer. If you have a current employee commenting on their own bias-based experience, that's an easy one. You definitely have a duty. And your scope is not only the original, I need to find out what these bias-based incidents refer to. This is, I wish I could remember the name of the logical fallacy. Maybe some of you will remember, but there's all these things, a list of logical fallacies, shortcuts that our brains tend to take. And one of them is if you find the answer to a question, like for example, the question in scenario 1 is, what are these biased incidents? You now have an employee who's commenting, this is what my own bias-based experience is. There's this temptation in our brain or logical fallacy that it's the only answer. And so you have to, you know, keep your mind open. We have plural references here, bias incidents. So your scope is what happened to that particular employee or group of employees, and also what is everyone else talking I think a tougher question is, what if it's just community members? And this guy is, this particular individual who's being complained is just a known harasser. Is that anything that we have a duty to investigate? That's a tough one. I don't
Right.
know.
In this case, it was a community member, and then all of the comments below it were former and current employees chiming in. So I guess the former employee piece is, you may or may not need to do that.
I think you do, to the extent that the responding or the person
Right.
being accused is still employed with you.
Right.
That makes no difference whether
Right.
the complainant is, as long as the responding employee is still employed with you, absolutely, you have to.
Right, I was thinking more like if the current employees had experienced such egregious behavior that you terminate him or that person before you even hit, you know, it's always good to have more evidence versus less to kind of bolster your termination, but you know, if this is one of these Me Too situations where there's 34 complainants, you may not need to go to the former employees.
True.
We're down a rabbit hole, we'll continue.
Marcia works as a receptionist at a nonprofit organization. Marcia's direct supervisor, Bailey, frequently comments on her appearance and openly discusses her own sex life. Excuse me. And asks other coworkers about their sex lives. This is a common fact pattern, only because I think right now we seem to be getting a lot of advice and counsel questions about this fact pattern.
Things have gone off the rails in the American workplace.
It's true. At one point, Marcia tells Bailey that she doesn't want to discuss this part of her life in a professional setting. After this, Marcia feels like Bailey goes out of her way not to speak with her. Marcia also notices that the assignments and shifts she's been given have been changed to less desirable ones. Marcia comes to you, the HR director, for guidance only. Listen, I don't want you to do anything. This is Marcia talking to you. Please don't take any action. I don't want to get in trouble. I work for Bailey, and I really don't want to stir up any issues. There's a lot of interrelated issues here, but what's your first response to Marcia when she comes into you?
You still have a duty.
Yeah, go ahead. Go ahead, Carol.
You can't ignore it.
Absolutely. Cannot ignore it.
Yeah, I was
So
gonna
what
say it
do you
sets you up for liability down the road if you don't look into it, because well, Marcia may not want you to investigate it. It could continue to happen to someone else.
What do you tell her? Either Carol or Heather. What do you say to Marcia? I agree with you completely. Can't ignore it.
I hope you'd have it in your policies about your obligation to investigate.
Yep, you should have it.
Yeah.
Use that as your backup. I think ways you can, work out ways you can protect Marcia and ensure her work comfort level.
Yep.
Can you promise confidentiality here?
No, not entirely.
Carol gets the gold star up today. No, not entirely. I think that's exactly the right answer. You can't promise it. So here's how I would respond to this and how we often counsel people to respond in sexual harassment trainings. Oh, Lori says, oh, I missed it. Tell her that you have to have a conversation with Bailey. Exactly. So I usually stop people or advise, right? I'm not having these conversations, but I advise HR people or, supervisors, whoever is receiving this report. As soon as you hear those words leave Marcia's mouth, I don't want you to do anything. I don't want you to say anything to anyone. You need to stop there and say, Marcia, I really appreciate you coming to me. I have an open door policy. I always want to hear what issues employees are experiencing, but you need to be aware that I don't have a choice. If what you tell me next rises to the level of a potential legal violation or something that might put our nonprofit at risk, I have to act. And I do that not because I don't want to be respectful of your wishes, but I have an obligation owed not just to you, but to every other employee who works with Bailey or who may have this kind of interaction. So here's what I can tell you. We have policies that prohibit retaliation. If she's already told you that she's started to get assignments that have changed to less than, what you're telling me, if that turns out to be true and accurate, is retaliation. That looks to be retaliation. I have no choice. And we prohibit that. And that is also unlawful. We have to take action. We don't have a choice. What would you do in terms of an investigation? What would be your first step? Conversation.
You asked for specifics, right, from Marcia?
Always, and this comes back to something I said a few slides ago, always start with the complainant. You might not choose to do it right then and there. Here's probably what I would do. Ask Marcia if she would be willing to put the specifics in writing. She comes to you, she makes the report. Would you be willing to put the specifics in writing? I'm not requiring it. It's just really helpful for me as I start to review this. If she says no, he can say, all right, I'm going to need to take a few notes if that's okay. I'm not going to share my notes with anyone. I can't guarantee confidentiality, as I said, right? If we have to take action, it's going to come out that this report was made, but we're not going to let anybody retaliate against you. And maybe you schedule a time to meet with Marcia after you've had an opportunity to really think about the kinds of questions you want to ask, or you take it right then and there and just say, especially as you get a little bit more experienced, you will just write down, okay, who else was there when she's having these discussions about her own experiences or discussing other employees, their experiences. Think about who, what, where, when. Sometimes why, but mostly who, what, where, when. I always write that. So we do a lot of these investigations when something is high level. And people are wanting to bring in a neutral third party. Carolyn and I, a lot of others in our group will end up doing these just like you all will. I usually write at the top of my notes page, who, what, when, where, and it's my checklist. Who else was there? What specifically did she say? When did this happen? And you want to get every single occasion. Sometimes people can't remember specifics. I know it was last Thursday. It's happened a couple other times, but I can't remember when. Okay, keep asking all the follow-up questions you need. Is there anything about maybe where you were? Was it springtime? Can you put a ballpark on when this happened? Is there any other events around that time that might give you an idea of when this happened? Those are all going to become important in substantiating, meaning whether you determine as the investigator that these did happen or did not happen. All good answers. Then I would go to Marcia. When you've had the opportunity to have that conversation, Bailey. When you've had that opportunity to have the conversation with Marcia, you've gotten the details as specifically as you possibly can. I usually then go to Bailey unless there are key witnesses. And then I will go to the witnesses before going to Bailey. And by key witnesses, I mean, Tina was there the entire time. She overheard all of this. I would go to Tina before I would go to Bailey, because I want to be able to say to Bailey in my interview of Bailey, well, Tina heard this. What's your response to that? Is it true? What's your side of the story? In order to be able to do that, you have to have the count, whatever the other story is. We're going to talk about ways in which we commonly see workplace investigations fail. All right. Number 10, not taking investigations. This comes back to those bias incidents hypo. People tend to think, this really isn't very urgent. This happened a long time ago. This involves people who don't even work here anymore. I'm not going to get it. I'm not going to get into the details. 2, it's not reported to the right person, right? Initially, it's your supervisor that comes to you with this, and it's been reported 2 months ago. They didn't come to me with this, so I really should not be investigating. Wrong. You should be, anytime you're seeing issues like these, harassment, retaliation, discrimination, bullying depends on your policy, and we can talk about that. But hostile work environment, absolutely. It's not in writing. You should have a policy that says we're gonna ask employees to put it in writing, but we're not gonna require it. That should be your practice. The complaint doesn't use the right words. What if I say so-and-so's a jerk only to me and to no one else, and I happen to be the only employee of color? Is that a discrimination complaint? Is that a harassment complaint? Probably, right? It's based on, it could be based on a protected class, even if it doesn't use those words.
All right, so fail number 9, not clearly defining the scope of the investigation. So this kind of happens in 2 phases. So the first phase is you want to have a sense of what your investigations overall, before anything comes up, are going to look like. Are you the decision maker, or are you just a reporter? What is your role? Are you going to be saying a conclusion? And Tara and I experience all different varieties of these in terms of what the client is looking for. Do they want us to make a conclusion that the individual employee violated the policy, or do they just want us to report the facts? So that's something you want to get kind of ahead of time. What is that going to look like? The second part is, how are you going to tailor the scope of the investigation to the allegations themselves? So in this case, as Tara's saying, you know, the facts lead you down the path, but what are you trying to get out of this? And how can you contain the scope as best as possible, so that you know when you've achieved the outcome of completing the investigation and taking action on it, if that's your role?
Yeah, I think for a lot of you, this may look like, okay, who am I investigating? Who are the responding parties? If it's, you know, someone who's high level and I might not be the sole decision maker on a termination, then you're still going to do your investigation, and you should still be generating a report. And then it's, okay, who's the audience of my report? It's all those decision makers. Maybe it's the president of the company or the CEO, or maybe it's, you know, if the investigation is of the president or the, you know, CEO, do you have a board of directors that you're giving this to, or what do you know, call counsel, because that's a sticky situation.
I was going to say, and do you need to bring in an outside investigator, which can be a time-consuming and sometimes expensive proposition, but in certain circumstances, it might be the right call. Like when, for example, your president is being accused of harassment, sometimes it's really helpful to have a neutral third party being brought in, so that you can point to that. It's a little bit more insulated from your position within the organization.
The other time I would think about bringing in an external investigator is if you have substantial potential for legal liability. Because if you do have a case, that investigator is going to need to testify, right? And so you want it to be somebody neutral. You want it to be somebody who's got, you know, doesn't have skin in the game necessarily. If you've already had several, let's say, performance discussions with this employee, you already have sort of a documented history of interactions with this employee, and they may feel that you're not neutral or impartial. It's sometimes just better to refer that out to allow you know, the company and or the organization to be insulated from those allegations. Failing to document appropriately. Number 8. I can't tell you how many times I have seen investigations start down a road that are handled internally and have to get maybe during the course of the investigation, new allegations come out and they go to an external investigator, and I am in the position of reviewing what's been done so far. Yikes. Sometimes this can be very problematic. What I see very, very often is that the investigator sat down, did not have any specific questions at all listed on their page of what they wanted to ask or what kinds of factual findings they wanted to inquire about. And so they let the conversation go very naturally. And it looks like, so-and-so made a discrimination complaint about you. Is that true? Or what happened? You know, they may ask the first first question appropriately, and the employee says, that never happened, so-and-so has it out for me because I gave them a poor performance review last year. Okay, thank you, and that's it. They'll often not ask for any documents or emails. Let's say the complaint referred to emails, and you haven't kept the emails, or you haven't printed them out or brought them to the interview. That's a really key one. When you're taking notes, avoid inserting your own perceptions or narrative in a summary way or vague way. So I give the example here in parentheses, he appeared nervous. Well, nervous is a little bit your perception of how they looked. I want everything to be as impartial and fact-based as you can. If somebody looks nervous, what are they doing? Usually, you know, the leg is shaking a little bit. Maybe his voice is quivering. His face was red. He was speaking very quickly when he answered the questions. Those are the kinds of descriptions I want to see in notes in an interview. So you should have very detailed notes. This isn't necessarily go into documenting, but I advise investigators to print the policy that you're reviewing out. So if it's a discrimination complaint, print out your discrimination policy. Let's say it's a complaint about bullying. Print out your bullying policy. Have it in front of you when you're asking questions. It will remind you to come back to what it is you're actually supposed to be asking and finding. Because often the standards are they're specific, and you're trying to figure out, I've had bullying, these are particularly true for bullying investigations, bullying complaints where, you know, it has to be intimidating, for example, in order to meet the definition of bullying under that policy. So you want to start asking questions about whether it was intimidating of the employee and of the person who's being accused. You should definitely note what you've told. I usually do this right at the outset. In all my investigation notes, it has the same 4 paragraphs. These are I call it my spiel that I go through with every complainant and witness. We expect you to participate. We want your full cooperation. That means you're telling the truth. Our policies prohibit retaliation. So if somebody retaliates against you, you should contact me and we will respond quickly and appropriately. You know, making false statements is problematic. We don't want you to do that. So please, you know, participate fully, tell the truth, and you know, let me know if you have questions. This isn't, I usually also include that this isn't a one and done. If you remember something after the fact, please contact me. You include a detailed analysis and conclusion and findings. We'll go through that in our high.
All right. Fail number 7, not closing the loop. So we talked about the scope of the investigation and making sure that's really well defined. The second part of that is making sure that you're completing all the parts that you're supposed to complete. So if you need to make a determination about whether a policy was violated, that needs to be completely done. And so this is really tempting. People can kind of say, so you're the investigator, you're doing the investigation, you go and ask so-and-so and so-and-so and so-and-so, and you figured out what happened. No problem. Everything was fine. This didn't even really happen. And you just sort of stop, right, with the investigation. You need to close it out. You need to include your conclusions. You need to make sure that you're being thorough, even if what you're finding is that you're finding that a violation didn't occur or that this wasn't a serious situation. It still needs to be documented appropriately. And then the last part is, I mean, we're talking about the investigation itself and doing the report and all of those pieces. But after that, you know, is there going to be a punishment? Is there going to be discipline? Is there corrective action? And as Amelia is saying, like, how do you, she said this a little bit ago, how do you kind of reinforce the existence of your policies after the fact to make sure that you're doing as much as you possibly can to prevent these types of situations overall in the organization? Now, you don't want to do that kind of as part of the, you know, with this investigation ongoing, but it is a kind of an opportunity after the fact to reflect on, are our policies up to date? Are they sufficient? Do people know about them? Do people know that you can't retaliate? Are they scared to come forward with a complaint? What does all that look like? And do you need to fire someone? That's kind of
Dun, dun, dun. Not considering, that fail number 6, not considering past practice or past discipline. Although every investigation is different, every set of factual scenarios is different, you also want to be thinking about how consistent are we being? For those of you who have labor unions, past practice is important because even if you don't have a specific policy, if you deviate from past practice, it's something that the union or the employee can read. And so you want to make sure you have some sort of objective reason and document the reason if you are deviating. So for example, we haven't disciplined employees for this in the past, these kinds of, inappropriate conversations, but this inappropriate conversation took place in view of customers, right? So that would be a reason to deviate. That's an objective, non-discriminatory reason. Think about, why are we mentioning discriminatory here? This would be the claim that the employee who's been accused would make. You singled me out for treatment that I did not deserve in the course of your investigation because of some sort of protected class reason, because I reported misconduct or because I have a disability. Almost everybody fits into a protected class, so you always need to be thinking about those.
I like your meme.
I did a lot of comedy memes this one.
Did you make that yourself?
Yeah. It was
generator.
meme generator, yeah.
All right.
I have many talents.
I mean, you gotta keep it lively sometimes. All right, so number 5, fail number 5, not knowing your internal complaint or disciplinary policies or procedures. I've kind of beat that one like a dead horse, but at the same time, you, at the next layer down, you want to make sure that all of your supervisors, management, everyone knows what these complaint procedures and disciplinary policies look like. It's really important so that, first of all, they know when to recognize a complaint that could trigger these. And then the second point is so that they know what to do and they don't just freeze and change the subject when an employee comes to them and say, so-and-so has been speaking to me in an inappropriate way, or whatever it is. That trickles down into collective bargaining agreements, the internal complaint procedures in your policies, and then personnel policy requirements as well. So those are kind of the areas where you would go to find them and to make sure that your supervisors and management are aware of them as well.
I don't think there's much crossover between, did anyone attend the supervisors training as well as this one? I doubt it, because it's kind of geared towards different audiences. I want to pause for a moment on the due process requirements bullet. For those of you who are public employers, does anyone know what the Loudermill process is? Heard of Loudermill? I see Carol shaking her head.
Yeah, that the employee has a right to present their side of whatever the investigation is about or the disciplinary action.
Exactly. If you are a public entity, if you are a government agency, so I'm not talking to the rest of you in this room who work for construction companies, private companies, whether this same process exists under a collective bargaining agreement depends on your agreement, but it's likely to be very similar. So only if you have a union is this probably going to be similar, but only for government employees. Almost always in Maine, you will have a due process requirement to follow because you have what we call a property interest in your employment. We can't deprive you of your public employment without due process of law. It requires 3 things. Notice, so that means the employee, and we do this in writing specifically to prove that we have provided adequate notice. So the employee gets notice of whatever it is that they're being accused of. A hearing, and I use that term loosely, the term is hearing from the case law, but it's a meeting with you and whoever the decision maker is, exactly as Carol said, to explain the employee's side of the story. So that's what the notice is important for. They need to know what they're explaining. And lastly, they get an impartial decision maker who will give them appeal rights. So that's the last piece. So the way this process has to go for the due process, and the term Loudermill that I'm using is a case that created these. It's a US Supreme Court case, decades old, but it created these process requirements for public employment. You always have that meeting with the employee and the decision makers. You give them the opportunity to explain their side of the story, and then you say to them, thank you, we'll consider it, we'll take that under advisement. You end the meeting, and then you issue your decision. Even if you think you may terminate the employee before the meeting ever starts, you have enough evidence, you know what the facts were by this point, you never make the decision in that meeting. That is implicating due process requirements, and it's kind of problematic. So just be aware from the public side that it is a bit different. I covered it with the supervisors last week, so hopefully that word, starts to get people start to understand there's a different process for public employees, but you all should be aware of that too. We talked about internal versus external. Think about legal issues. We've talked a lot about, and this is intuitive, and you'll grow more intuitive as you get more comfortable in HR roles, but legal issues, right? Any protected class basis, knowing what the protected classes are. We've also covered this a little bit, but they're changing in Maine, right? So we have some new ones. Familial status, having kids in the house, or taking care of adult dependents is a brand new Maine protected class. So know what they are, right? So you can spot the legal issues. And if it's a legal issue, that tends to be when I think of an external investigator, properly trained. Here we are doing the training. So knowledgeable of the law, understanding, I think, approaching psychologically complex matters with compassion and empathy. That's our goal for everybody. A little hard to train on that.
All right. So you want to be careful about how you're gathering evidence during your investigation. If any evidence is gathered through coercive methods or through other illegal or improper methods, the entire investigation can be discredited. It can be kind of tainted, as it says there. If you need social media evidence, if you're doing an investigation of a social media post that's allegedly inappropriate, you want to ask the individuals involved, start with the complainant, to provide as much as they can from the social media. You can also ask witnesses, and then finally you would ask the respondent last to provide anything. Usually this is something that we say, please screenshot that immediately before it gets taken down.
Yeah,
that's what we like to say. So employees, applicants, other individuals, they have privacy rights around their personal social media in the state of Maine. So an employer cannot require or coerce an employee or applicant to disclose or request any passwords to a personal social media account. You can't coerce or require an employee to access their personal social media accounts in the presence of the employer. So these are just sort of things to be aware of when you need that evidence. You really just need to ask for it, and also just do your own search, public searches.
You can access it yourself.
Yeah.
If you happen to be friends with the employee, you can access the post yourself. Or as Carolyn said, you can always ask witnesses to give you screenshots.
Yeah.
You just can't ask someone to give the password of their own account.
Yeah. And with our school investigations, the students like to take take photos of the screenshot.
So you can't get the metadata and find out who took the screenshot.
Yeah, that's kind of advanced for us, but that's how the children do it. They figured it out. All right.
The image is a common legal law school, the fruit of the poisonous tree. If you have tainted evidence, and especially in a criminal investigation, it can overturn the conviction.
It's more like the roots of.
I know, the fruits of the poisons in the roots, I guess. Yeah. Let's take some artistic liberty.
All right.
So the last, second to last, I guess this is my last one. Number 2, fails of investigation. This is every, I don't want to say every, but almost every sexual misconduct investigation. Anytime you have a sexual harassment claim that involves only 2 people who were present, the person who is accused may have one story. The person who is reporting or complaining has a different story. And I regularly get HR directors, investigators say, well, I have no basis to say who's telling the truth. How am I supposed to know what happened? You do have a basis. You always have a basis, right? So I've listed some of the factors that we use, particularly, we do a lot of sexual misconduct investigations under Title IX, which are college and university sexual misconduct cases often involve allegations of sexual assault or dating violence. You almost always have 2 people who were present. And so you're looking at other external factors to evaluate credibility. Who, between the 2 witnesses or the 2 parties, who's telling the truth? Those are your credibility determination. Inherent plausibility. Sometimes the story just doesn't make any freaking sense. That's the inherent plausibility prong. That doesn't sound like it could happen.
That's your legal conclusion at the end of
Yeah, that sounds like nonsense. Timeline of events, right? Think about, right, Perry Mason. Does this person have enough time? Does that really make sense? Are there external corroboration factors they can use to tell whether this is accurate or not? Corroboration of evidence. So very, very often in sexual misconduct, especially when you have very serious sexual assault cases, you'll get outcry witnesses. An outcry witness is the person that the individual who is claiming to be a victim, the complaining party, calls immediately after it happened. I called my mom. I told her that it happened. I was crying. We went into great detail, and then you're able to interview the mom. And now actually you do have record of a 45-minute call that took place on that day. So now you're starting to put together pieces that do start to line up. A big one that you're going to use probably more than corroboration is motive to lie. Is this person motivated to lie because of retribution? Are they exaggerating? Things like that. Specificity, that's a really important one. How many of you remember the Christine Blasey Ford hearings where she was talking about her experiences and her reports of, I think one of the things that stuck out to most people was she described how things smell. And that was, I think, for a lot of people, a moment that was very poignant, that felt, whether it's truthful or not, it's very specific. And there's something that lends credibility when you have that level of specificity. Consistency with other statements or evidence, that one's a little self-explanatory. So you're going to look at other people's accounts and is this consistent? Lack of cooperation. You are not a court of law. What you investigate does not have to meet evidentiary standards. Just because it may lead to legal process does not mean we follow it. I consider hearsay. I consider things that would be inadmissible in court all the time. That's all part, I decide how much weight to give it, but that's your role. So if somebody doesn't cooperate, this isn't the Fifth Amendment. It's not, I'm going to take into account, you have the right to remain silent, and I'm not going to take that into account. If you've been accused of serious misconduct and you're not cooperating with me, I'm going to take that into account. I think somebody who didn't do this probably would want to talk to me and explain it. Objective factors, including disciplinary history and performance. All right.
All right,
Last one.
Number 1. So you've done this entire investigation. You recognize the situation, you realize what you needed to do, you outline the scope of your investigation, you interview all the parties, and then you just don't ask, especially the respondent, but any witness or complainant, if they did it. Did this happen? this doesn't need to be question one, you can get into it, but dancing around the information that you need to make your determination is something that happens all too frequently, because I think individuals, even HR professionals, are kind of uncomfortable in these situations, and they don't want to be perceived as being aggressive in their questioning, or you kind of want to go along with the individual's story and say, yeah, that makes sense. Like, wait a minute, this doesn't make sense. Did you do X, Y, and Z? Did this happen? You can ask those questions in a respectful way, but still ask those questions and get to the bottom of it. It's not helpful to have an investigation where you don't, it's really to the detriment of the responding party to not ask the difficult questions and get to the true answer of the situation.
Where I see this come up all the time is touching, sexual harassment. Get comfortable talking about things that are, inappropriate in the workplace. So saying, did you touch her breasts? I think a lot of people can become uncomfortable. This is a little awkward. This is the question, right? She's accusing you of having touched her breast. It's a private body part. Some people just have a bit more squeamishness with this. Get comfortable. This person is alleging that you put your hand on his leg and touched his penis. Can you say those words? This is where I often see people get uncomfortable. They don't want to ask that question, but that's part of running a professional investigation. You have to present the allegations and ask the question.
All right, so this time we got to this is kind of a long hypo, but we did get to the hypo before time was up, so that was it's hard to get through. All right,
Can you read it?
yeah. Okay, so you are the HR director at a bank. You receive a report from your employee, Tara, a bank teller, that Carolyn, another bank teller in the same branch, showed her a pornographic image on her phone without any warning. This is from a true scenario that was presented to us. When Tara told Carolyn that the image was offensive, Carolyn said she couldn't take a joke. Tara also reports that 1 week later, Carolyn was talking loudly to another employee about the lyrics of a rap song, and during the conversation said the N-word. Tara is extremely uncomfortable working alongside Carolyn and would like the organization to fire her for unprofessional conduct. How do you respond to Tara's complaint? All right, so we're going to walk through it. This is not a one and done answer. But what would your first step be?
Start investigating. Ding, 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 ding. Lori got that right. So what do you, Tara, let's say I'm in your office. So we're going to do a little bit of role playing. Obviously I'm Tara, she's Carolyn. I'm still in your office. What's the first thing you're going to do? Please fire Carolyn. She makes me so uncomfortable. I cannot work with her anymore. It's making me, I'm stressed out. I'm losing sleep.
We talked about this actually. Interim measures, we talked about interim measures?
I don't think
So that's a trick question.
we have.
Can you try to see if you can separate them in the workplace?
Ding, 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 ding. Ask Tara. Ooh, Michelle, good job. Ask Tara for specifics. So we'll put a pin in that because that is the first step of the investigation. But we didn't really talk about, since we're focused on investigations, we haven't talked about interim measures. So Carolyn, you want to explain what we mean?
Sure. So if somebody is coming to your office, regardless of how kind of credible their story sounds, if they are saying words to you like, I am uncomfortable working with so-and-so because of X, Y, and Z, I don't know if I can keep coming to work every day. I had to call out sick yesterday because I just couldn't look at them. You need to put into place interim measures. So that means measures that will make it tolerable for that individual to still come to work because they have some sort of layer of protection from this other individual. So the question for Tara is, like, can Tara and Carolyn work in completely different shifts? I've had clients who, like a fast food place, and you can go through the whole schedule for them and make sure that the individual is never cross paths, that there's 15 or 20 minutes between their shifts. Obviously, this may be more feasible in some organizations than others, but other interim measures. Could you allow Tara, probably not as a bank teller, but could you allow Tara to work from home for a period pending the investigation? Could you have them report to another supervisor, even if they're in the same space still, then they're not having to interact as closely. So these are the types of things to think about. It's almost like an accommodation that you're providing the employee on an interim basis, where you can kind of talk through it with them and say, you know, what would make you feel comfortable? This is what we would like to do. This is what may be feasible. How does that make you feel? Would this be possible?
One question I get all the time, speaking of interim measures, is when do we start to consider paid administrative leave pending investigation?
Yep.
What might be your thoughts on that? When would this move to paid admin?
Who would you put on it?
Let's hope that one's right. So Carolyn would be the person you're considering putting on leave. I don't think in this one I necessarily would go that step. If there are other adequate interim measures, I think about paid administrative leave when someone is being directly harmed. So this is not inappropriate conduct and potentially even sexually harassing conduct with the pornographic image that Carolyn's showing on her phone. A little different. So let's imagine a twisted fact pattern where it's actual such, you know, some kind of sexual touching. So, you know, rubbed up against me, or, you know, came up behind me and, you know, brushed past me in a very physically touching way. When someone is being harmed in the workplace, that's when I start to think about paid admin leave. Really, you know, serious allegations that if conduct during the investigation like that occurred, we could have a real liability problem. We've been put on notice of this. So let's go back to the chat. So our first steps are ask Tara for specifics. So let's role play a little bit. I'm Tara and Carolyn is Carolyn. So you're in the hypo. I'll just let you look at these and then we'll go back to the fact pattern because I think you do need to see that. What kinds of information do you need from me? What kind of questions are you asking me? Who, what, when? Good job, Lori. All right, I'm gonna start answering that, right? Who, so this was Carolyn. This was, we were in the, working in the same branch. This pornographic image happened last Thursday. We were just wrapping up our shift and she walked up out of nowhere and just showed me this image on her phone. It was a man's penis. I've never seen anything like this before. It had text on it. I don't even remember what the text said, but I was so deeply, deeply uncomfortable. I don't ever want to work with her again. And I told her, don't show me that. That's disgusting. And she told me I couldn't take a joke. And so
this happened in real life.
And then she was singing this rap song and, you know, I mean, look, I'm not trying to be judgmental. People like different types of music, but I don't think she should be using that language in the workplace. As she used the N-word and people were all around and they could hear her, customers even.
Sorry, you too.
Feel free to come off mute too and just
Yeah.
ask questions. That's what we wanted to do here.
Gonna say you'd want to know who those people were around that could back up the story.
Amelia was there, so one of my other tellers, and I won't make you guys role play. And Scott was also present. I don't think Amelia saw the picture on the phone. She just held it up for me to see. But she was there and she saw that I said that it was offensive.
I would go to Amelia and ask her if that's what went down. Her
You mean-
account of the story.
Do you think there are any other questions before we let Tara leave that we need to ask her?
I would ask if there was any other instances in the past that she could maybe bring to light, so you can kind of bounce off of that too.
Totally. That's a great one. So we've been working together for, I don't know, about 6 months, I would say. And actually, now that you mention it, 3 months ago, she told me this joke. And I honestly, I don't even understand what the joke meant, but I remember the punchline being, you know, something about sex. And I brushed it off at the time. I really didn't think it was that big of a deal, but you know, now that we're having this conversation, it seems like she's got some kind of sexual problem or something. I think that covers most of it with the complainant. I think you all covered very much the types of questions I would want to be asking. So the who, what, where, when, why. We didn't talk about why. I don't.
You offered it.
I
have a
offered it.
problem.
You have some sort of sexual problem. That just came out. I don't know. So who else was there? We talked about Amelia and Scott. When did this happen? Last Thursday, right? I think you want to slow everything down when you're doing an interview. Okay. So this occurred last Thursday. What about this rap lyric conversation? When did that happen? You know, just really take your time. Don't be afraid of pauses and talking about, you know, your witness is talking about the facts, you're taking notes, and it's just quiet for a minute while you're continuing to take notes. That's totally fine. All right, let's go to the next one. Now, let's imagine you've already interviewed Amelia. Her story is pretty consistent with mine, but now you're interviewing Carolyn. What kinds of questions are you asking Carolyn?
Do you use the specific dates and times so that Carolyn's aware you have information?
You can. You can. I like how you turned a question into a question, Heather. That's a good old lawyer move. You can. Absolutely. That's one tactic you can take, is to say, you know, I've received information that last Thursday you showed an image on your phone. What's your question to Carolyn? So I've received this information. What do you ask?
I mean, I think my first inkling would be to ask what the image was.
What was that image? That's a good. Heather has
Skip past whether you did it.
Not skip past it. I kind of like it. It assumes that you did it. I think this is a very lawyerly
That's like a cross-examination right there.
What was the picture? Then it assumes that she did it, and she has no opportunity. You know, the instinct is to answer the question. So I actually like that. We don't have to get that devious, right? You want to be thinking about, do you have, what's your response? What explanation do you have?
I never did that. I have no idea what she's talking about. She definitely, I think Tara has it out for me. The only photos I've ever shown anybody at work are of my grandchildren.
She's got grandchildren. She should not be doing that.
I have a question about that.
Yeah.
So in that situation where you're questioning Carolyn, would you bring up the person who had came to you with the information?
Good question.
Depends on the context is my answer to that. Do I need to for any specific reason? So now let's imagine that this is actually playing out in real life. Carolyn says, I bet this was Tara. She's had it out for me ever since I gave a bad performance review. She's really got it in for me. They seem to have guessed, right? And so maybe I'm probing a little bit more. Why do you say that? Did she say anything to you that makes you think that she's got it out for you? It's the first time, you know, she's going to probably assume and understand that Tara was the complainant. But I don't think I'm volunteering it. If the first question I asked Carolyn is, I've gotten information that you shared a pornographic image on your phone last Thursday. I'm wondering what your response is to that. I'm probably not going to say Tara came to me and complained that you did this.
Especially when they're witnesses, right? Right, because you don't know whether a witness complained and you're just sort of setting up a retaliation.
In a moment like that, though, when, you know, we try to keep things confidential, but we know we can't, and I'm kind of jumping back to the other hypothetical where the employee asks, oh, please don't let this go anywhere. Obviously, we have to approach it, but can we still always approach it in a way that we have to talk about this? We won't release your name, though, or is there ever times where you really have to release their name at some point in time?
You almost always do. enough contextual information will become apparent throughout the course of an investigation that the name will come out. That's why we say we can't assure confidentiality. I think these are really good questions. It's 3:58, so if you have to go, you have to go. But here's what I'd like to do. I'm going to very quickly pull up this template investigation report, and we're just going to type a couple of notes here on what should be in your investigation report. This is, I think, where the rubber meets the road, so to speak, on your investigation report. So I pulled them up side by side. So take a look. We've got our facts over here. And then we've got our investigation report over here. I'm going to minimize the people for a second. We've got our investigation report over here. So I've now finished all of my interviews. I'm not Tara. Let's imagine I'm Mary Jones for right now. I finished all my interviews as the HR person. And I now have to put together a report. So this has been started, right? Tara Walker submitted an email to her supervisor, alleged that Carolyn Liegner, a current bank teller in this branch, showed a pornographic image on her phone. A week later, complainant again complained in another email that Carolyn was discussing the lyrics of a rap song and used the N-word, right? We then always input the policies directly into our reports. So those would go here. Overview of the parties. You don't have to be this formal. You can skip over this.
This is more, some of this is the format of an outside investigator that might be able to.
So usually I summarize my interview notes in this section. So my interview with complainant will say, Tara said this, Tara said that. Interview with supervisor may say, Scott said this, Scott said that. Interview with Amelia, the witness, will say Amelia said, Amelia said. And then we get to findings and conclusions. So let's start with factual findings. What would those look like? Does anyone have an idea? Let's just imagine we can do 3 factual findings that come out of this investigation. Say we end up believing Tara's story and wanting to take disciplinary action against Carolyn. On Thursday, March, let's say 13th, what's it, 14th, Carolyn and Tara were in the bank branch, and Carolyn opened her personal cell phone and showed Tara an image. You can copy and paste the image if you want to get real specific about it, depicting a male penis with a meme, who knows what it says. I can only venture a guess, text. So that's finding number 1. Do you see how specific we're being here, right? We have everybody's different stories, but we want to then go ahead and say what happened. You may then have the next one be, I do not find Carolyn's account that Tara had it out for her, quote, credible, because Tara's account was supported by Amelia and Scott, and they do not have the same to fabricate. That might be another totally separate finding. Carolyn denied it, but I don't find her account credible. And here's why. That's your role. I want to be totally crystal clear. That's what you're asked to do in these investigations, is to make those kinds of findings. A conclusion, right, would be a policy violation. Usually these are one or 2 sentences long, but they would say, I find that Carolyn engaged in sexual harassment in violation of the company's policy on March 14th when she showed Tara that text.
In addition, could she be making a hostile work environment using derogatory terms?
Potentially. So hostile work environment is its own legal analysis. I would be very cautious before you indicate
Use
in
those
your
terms.
report that there is a hostile work environment created. A hostile work environment refers to, so you have two reasons that you can sue in a court of law. One is you've had adverse employment action, you've gotten fired, demoted, pay cut. There's certain defined actions that happen that allow you to sue. The second is that there's a hostile work environment. You may have the same job, you may have the same terms and conditions of employment, but it has become a hostile work environment and it allows you to sue. So that terminology has very important legal significance and it gets misused all the time.
And you're trying to prevent a hostile work environment by doing this investigation. So you would never want to put that in an investigation because it could be used.
Fair.
But you can do the policy violation
Policy violations.
in here. And then have you ever put like any sort of outcome?
No,
Any sort
you
of
wouldn't put the
that in there?
discipline because this is going to be used as the basis of discipline. That goes in the termination letter. Does that all make sense? I'm just going to stop sharing here. Thank you very much for sticking with us through all 3 sessions, even staying late. I know we've had to cram a lot in here. It's been a pleasure. Thank you all so much. And please reach out if you have any questions after this. We'll follow up with the slides.